Hello aspirants and welcome again to Legacy IAS Academy. In this current affairs lecture, we will be seeing the Supreme Court's judgment on a very recent case regarding the Tamil Nadu governor versus the Tamil Nadu state government. So this issue is regarding the bill. See, any bill cannot become an act. Any bill that is passed by the state legislature cannot become an act without the assent of the governor. In the same manner, any bill that is passed by the parliament cannot become an act without the assent of the president. Now, in this regard, there are certain powers that are there with the governors as well as the president. They can withhold, they can give the assent to the bill, withhold the assent, so on and so forth. We'll see them in detail with respect to the different articles. Now, with respect to this power, the Supreme Court has given a judgment and set a timeline as well. Now, remember, this case was regarding the Tamil Nadu governor and the Tamil Nadu state government, but here the president has also come under question. With in the sense is not the president, but what the powers of the president are. So, in a very recent judgment, now the judgment has just come in, wherein the 3-month deadline for the president is there to decide on the bill referred to the president by the governor. So, this bill is of which government authority? It is not that of central government, it's not of the parliament. We are talking about the bill of the state legislative assembly. So the state legislative assembly's bill, the governor can give the assent, withhold the assent, or can keep the bill aside to refer it to the president. In that case, the Supreme Court has come out with a judgment saying that the president cannot hold it indefinitely and have to take a decision within the 3-month deadline. 3-month timeline is what has been said. So let us see what are the powers, what are the relevant articles, and much more on this topic. Before we move ahead, there is an announcement to be made about the regular batches that is starting from 17th April as well as 12th May. So depending upon your timeline, start enrolling and start your UPSC preparation. Now, these are regular batches having 2 sessions every day, 10 to 1 p.m. and 2 p.m. to 5 p.m. from Monday to Friday. Now, there are aspirants who are working professionals who might have job throughout the week or colleges throughout the week. So for them, the weekend batches are there, which starts from 19th April. Everything remains the same. Only difference is that the classes will happen on Saturday and Sunday from 10 a.m. to 5 p.m. One more announcement about the free All India mock test series by Legacy IAS Academy for 2025 aspirants. So enroll yourself and take the advantage of this. You will get instant solutions. At the same time, you will be given discussion sessions as well for the same, which will be very helpful for you to increase your marks. So let's go back to the news. So what is the news? The Supreme Court of India, in, as I said, the state of Tamil Nadu versus the governor of Tamil Nadu, it has clarified that first, the judgment with respect to governor came in, and now recently, more recent is the judgment with respect to the president. So first judgment with respect to governor was what? That the governor must act on the bill in a time-bound manner. So when the governor is allowed to withhold the bill, the governor cannot withhold the bill indefinitely. There needs to be some timeline. The delay cannot be quite long. If there is a delay because of genuine reason, it can be told to the state assembly that, boss, there is a delay because of so and so reason. But if not, then the governor must act in a time-bound manner. I hope that's absolutely clear. So this was the judgment as per Article 200 of the Indian Constitution. The power with respect to the bill for a governor is under Article 200, and that for the president is under Article 201. Now, so the governor judgment came first, then came the judgment with respect to the president. So what is the recent judgment with respect to the president? Supreme Court, it has for the first time, it has never happened previously, for the first time it has prescribed that the president should take decision on the bill reserved for consideration by the governor within a period of 3 months from the date on which such reference is received. So the state assembly bill can sometimes, certain bills can be kept aside by the governor to and refer it to the president. The day the president receives that bill for reference, from that day onwards, within 3 months, the president has to take a decision on that. So decision on the bill has to be taken within 3 within 3 months. Now let us look at these two articles. Article 200 of the Indian Constitution talks about assenting of the bill. It consists of granting the assent. What is the the simple, it is a very simple thing. What is the simple thing? The state assembly passes the bill to the governor. The governor simply approves the bill, and once approved, once the assent is given, the bill becomes an act. End of story. No delay, nothing has happened. However, the governor can withhold the assent, right? The governor has the authority to refuse the assent to the bill. So here the governor can withhold the assent. That's the second thing the governor can do. The third thing is the governor can return the bill for reconsideration. It can return, he, she or they can return the bill for reconsideration by the state legislative assembly itself, back to the state legislative assembly for further review and reconsideration. So this is the third thing that the governor can do. The fourth thing that the governor can do is reserve it for the president's consideration. In certain cases, the governor of that particular state can reserve a particular bill for the consideration of the president, right? So now once the bill goes to the president, then what happens? Article 201 of the Indian Constitution talks about it, that if the governor reserves the bill for the president's consideration, then what happens is, number one, grant of assent. The president can approve the bill and the bill becomes an act. So granting of the assent. Second is withhold. So when the assent is granted, no issues. It generally gets granted within 3 months, no issues. But the other thing that the president can do is withhold the assent. The president may choose to withhold the assent. I hope that's clear. So what happens is the governor has sent it to the president. Either president gives the assent or withholds the assent. Now for non-monetary bills, non-money bills means bills that are not as under Article 110. Under Article 110 talks about money bills. They are money bills, and they are introduced with prior recommendation of the president and the governor respectively only, so they are generally passed. But for non-money bills, if the president withholds assent, the president can direct the governor to send the bill back to the legislature for reconsideration. Here also the bill is being sent back to the state legislative assembly. The governor was also able to send back. The president is also able to send back. Now, once the bill is sent back, legislature is required to act within 6 months. If the bill is passed again, it must be resubmitted to the president for final approval. So, president can send it back for reconsideration, but if the state legislative assembly passes it back, either in the same form or a modified form, it has to again be sent back to the president directly. Then governor is not involved. Then the same procedure of sending it to the governor first and the governor deciding whether to give the assent or not, or send it to the president, all that will not happen. Then the bill directly goes to the president. I hope that's absolutely clear. Now, the timeline is given. The Supreme Court has said that within 3 months, the president has to take the decision. What if the president does not adhere to the timeline? If there is delay beyond this period, means beyond 3 months, then what should be done? Appropriate reasons would have to be recorded and conveyed to the state assembly, is what the Supreme Court has said. There can be delay, genuine delay, justified delay, but in that case, please inform the state legislative assembly as to the reason of the delay there is. Because see, bills and all can be related to day-to-day activities. There can be related to some important issue, which is a pressing issue, so on and so forth. And it is the state assembly or the parliament which is the will of the majority, because there is a democracy, right? So you cannot just like that neglect it and keep on delaying it and lead to things like red tapeism and sorts. As a result of which, there has to be a time-bound response. If not, the reason needs to be recorded and conveyed to the state assembly. Now, what is the significance of this judgment? The significance is within 3 months, when the president is being asked to respond, it is significant because Article 201 of the Constitution, so far, as of even now, this is the judgment. Article 201 actually has no time frame that has been set for a presidential decision. So basically, the Constitution of India does not prescribe any time frame, but now the Supreme Court, even though in the Constitution it is not mentioned, has come up with a time frame. Is it justified? Probably yes, because the idea is that the work should proceed. You cannot keep on withholding the bill. That is the justification that is given by the Supreme Court of India. Right. The court has also said for future such cases that the court will not be powerless in such cases wherein there is delay. The court can intervene if certain constitutional authority is not doing its job or creating delays. The court can intervene. That's one thing. The court can intervene suo motu also. Suo motu means on its own, directly the court can intervene. No one has to ask the court. That is one thing. Second, if the governor is receiving the bill for the president and the president in turn withholds the assent, then it shall be open for the state government to assail such an action before this court. That means what? That if the president keeps on holding the bill for more than 3 months and there is no proper justification or reasoning also given, then the state government is open to reach out to the court to get a resolution for the same. So here the court has made it very clear you cannot keep on delaying it, and court has the right to intervene. At the same time, the state assembly or the state government are also open to reach out to the court for this. Now this everything here is very important. The static portion, article 200, 201 becomes very important. Another question can be asked in this regard is this judicial activism or judicial overreach? So write down in the comment section whether this forms judicial overreach or it is just judicial activism. What is the difference between the two, and how far should the court intervene in these kind of things? Thank you.